Welcome again to the Melling Law YouTube channel, where we talk about different estate planning topics relevant to people living in Utah. And we're continuing our series on estate planning fails. These are things that people do as a way to avoid probate or accomplish some kind of estate planning goal, but they often go awry because they're not done properly. So number 2 is most definitely the sugar bowl deed. And this is just kind of a term of art, but it describes any kind of situation where we have someone who wants to avoid probate. They want to transfer their house or any other real estate to their children, but they don't want to transfer it during their lifetime. They want to wait till they've passed away, which, if that house is in your name, the only way that's going to happen is through probate. Now, one workaround is that they'll sign a deed and they'll put it under the sugar bowl, so to speak, and that doesn't happen anymore, but it that's kind of just the term that the industry has used over the years. But they'll put it under the sugar bowl and say, here's the deed to the house, I've signed it to you, and if I die, go ahead and record that, and then it'll transfer to you without probate. Now, there are a couple major issues here. The first one is that you've signed a deed of your house to your children, and they can grab that deed and record it anytime they want. So that's the first issue. But even if you trust your children, the second issue here is that these deeds are not able to be recorded with the county more than 3 years after they've been signed. So if you've signed a sugar bowl deed and you thought, that's my substitute for a living trust or a proper estate plan, and I'm just going to leave it here and the kids will take care of it, odds are 3 years are going to go by and you've forgotten about it because you thought that it was taken care of, and it turns out it's not, and then the children have to do a probate anyway. Another problem is let's say you don't pass away suddenly, but that you have some kind of degenerative illness, dementia or Alzheimer's. You would even lack capacity for the 3 years leading up to your death to even sign a new estate plan or a new deed. So even then, your deed is not going to be recordable and the plan isn't going to work. So estate planning fail number 2 is sugar bowl deeds, where you've signed a deed but you don't record it, hoping that that's going to help you avoid probate. I've seen the same issue with a lot of other types of writings, whether it was some kind of gift, a notarized statement stating that I'm giving a lifetime gift to this person. It really doesn't matter. If title has not transferred and been recorded within 3 years of signing that, then it's not going to work out. So thanks for watching. If you have any questions, please feel free to call us or reach out to us on the website.